Hi, this is the audio review of the first chapter of the U.S. legal system. In this chapter, we're going to learn the following. We're going to find out the primary sources of law within the U.S. legal system. We're going to understand the function and processes of the federal and state court systems. We're going to look at different types of law in the United States, and then examine some common legal resources. Why is this important? It's important to understand the legal consequences of your decisions. While I realize that most people in this class are not going to become lawyers or go on to law school, sport law is a vital area for everyone in the sport management field to know, whether it's risk management or whether it's hiring and firing or some sort of ocean connection. What we're looking to do here, whether you're working directly with clients or with a team, any area in the sport and rec employment context, is we need to understand the legal consequences of our actions and of our decisions. We can see that understanding the law will make better management decisions. We're going to understand legal terminology and hopefully gain an interest in the law. As you can see, sometimes in the PowerPoints, there will be a YouTube video or a link to another one. If you want to copy those down and look at them at your leisure, oftentimes they do present some vital information. So what is the law? The law is actually a body of rules of action or conduct that has controlling authority and binding legal force, meaning it's a list of rules and regulations that describe what we can do. It monitors our behavior. It manages our conduct. At the end of the term, though, it has legal force. If we do not act in the way that's prescribed, we can get punished, and that would be whether monetary punishment and fines or actually some sort of incarceration. So it does have legal force to it. We're going to look at the U.S. Constitution. The Constitution is a document that governs and limits the government. When we look at it, it really is a guarantee of our rights as citizens because it sets up what the government can and cannot do. We're going to look at federal and state legislatures. They're ones that enact different statutes. They're the ones that create state law. States have what's known as unlimited police power. Thereby, states are much more, have the ability to govern our behavior much more than the Constitution could in the federal government, because Congress can only pass laws that are described within the Constitution. We're also going to look at state and federal courts. These are three different manners that law can be created, either through constitutional law or through federal legislature, or this idea of state and federal courts or common law. The state courts and federal courts interpret the different statutes or laws created by the states, and they interpret the Constitution. All trial and state courts begin at a district or trial court. Then there's different types of appellate or appeals courts that lead up all the way to the U.S. Supreme Court. So we look at the U.S. legal system, the balance of powers, checks and balances, I think most people have known them as. The executive branch is headed by the president on the federal side, the governors on the state side. What do? They enforce the laws. If you imagine the government as if it's a corporation, the president is the one who actually runs the company, and we'll look at the legislature, the Congress, and the state governments as the people who are the board of directors who create the vision and guide where the president is allowed to go. So we look at the executive branch, they enforce the laws, the legislative branch, the Congress and state legislatures, enact new laws and amend existing ones, and the judicial branch, the courts, actually interpret the laws. So each one has a check and a balance against some of the other ones. As we looked at before, we have four different sources of U.S. law. We have English common law, which is developed through the court system. So when you go to trial and then it goes up through the appellate level, the decision actually creates a new law that's specific to that fact pattern. We have the constitutional law. We have statutory law, or law created either by Congress or our state legislature. And we also have administrative law, rules and regulations created by an administrative agency of the government. Looking at common law, it's based on this system of precedents, stare decisis, that allows us to be guided to behavior. If we see somebody did some sort of behavior and they are punished for it, we can expect, because we are governed by a system of laws, If we do the same behavior, we should be punished in the same way. A precedent is a rule or example established in an earlier case that's to be followed by a court of the same or lower rank in future cases. In other words, there's precedent set. If a court decides a punishment for certain behavior, everyone within that jurisdiction that leads into it must follow that same decision. Once a precedent is established, the only court that can overturn it is an appellate court higher than that court. Or the legislative body can go in and say that that law should be changed and create a new law. Stare decisis is the principle that those precedences will be followed. Courts are reluctant to overchange law. Courts do not like to change the law. They do not like to overrule others. They will if they decide to, of course, but this system of stare decisis is built on the fact that courts will follow the law and not change it. It gives us comfort. It gives us good direction of what our behavior should be. Constitutional law comes from the U.S. Constitution and state constitutions. It creates our government and limits their power. Any statute, court ruling, or administrative rule cannot contradict the Constitution. The Constitution, briefly showed some of it here. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. That's the preamble. We don't speak like that anymore. Think about when this was created. We're 12 years or so from the American Revolution. We just got finished and we had a government, the Articles of Confederation, that wasn't really working very well for us. So a bunch of people decided to get together in Philadelphia, Pennsylvania, in order to form a more perfect union. How can we create a federal government that will govern us better, that will provide for the common defense, ensure domestic tranquility, promote the general welfare? If you look at the Constitution, there are 7 different articles. The first article talks how the legislative is created. How is Congress created? And at this time, you had 2 different schools of thought. You had one group, states like Massachusetts, Virginia, New York, states that are very large with a lot of people, wanting a federal government that can create laws based on representation. If we have more people than the other states, we should have more voice. You have other states like South Carolina or Delaware that say, no, if we're states, we should all be equal, which leads to the bicameral effect of the House of Representatives and the Senate. We look at Article 2, the executive, describes what the president can and cannot do. Article 3 sets up the court system. Article 4 talks about full faith and credit to other states, meaning we're going to be a federal government, we're going to be one nation, we have to be able to work between each other, and all states are going to be able to interact with each other. Article 5, amendments, describing how we can create amendments to the Constitution. Article 6, debts and agreements prior to the Constitution will be valid. Kind of interesting, saying things that you've done business-wise before the creation of the Constitution, things that you did under the Articles of Confederation will be held. If you have a big debt to somebody and the Constitution gets passed, you're not going to be absolved from paying that debt. And Article 7 talks about how it's going to be ratified by 9 states and then it becomes the law of the land. Look at some of the Bill of Rights. And in our Sport and Rec discussion, we're going to be talking about a lot of these Bill of Rights. Like Amendment 1, Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people to peaceably to assemble and to petition the government for a redress of grievances. We're going to look at this. Question for everyone. What does shall mean? We hear that a lot. Congress shall make no law. Shall is actually more than will. Shall is almost 100%. It's almost an absolute. Will is probable. Congress shall make no law abridging the freedom of speech. Has Congress done that? Sure has. With two classic examples, you cannot yell fire in a movie theater, you cannot say bomb on a plane. Congress has done a lot of abridging freedom of speech. And when we look at our constitutional law discussion, we're going to see when we talk about Congress, we mean the federal government and the state government. And when we talk about the state government, we mean public education institutions. We mean public colleges too. So if you go to a public school or a state school, then the government has to respect your constitutional rights, like abridging the freedom of speech. And we know they do. And in certain aspects, it is allowed. A private school is much more likely and has a lot more ability to curtail your freedom of speech, because private institutions most likely do not have to have the same constitutional guarantees. Amendment 2, you can read about the right to keep and bear arms. Amendment 3 is pretty interesting because it talks about soldiers being quartered in a house. Amendment 4 will talk about the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation. This is very important when we talk about our constitutional discussions. The right to be secure in your persons, houses, papers, and effects. We're going to talk about drug testing. And drug testing, you certainly should be protected against giving the government your blood, urine, or other types of information, but upon probable cause. I think many of us in the past have given drug tests for different reasons, whether you're trying out for an athletic team or something along the line, and you didn't have probable cause. Nobody said, I suspect you of doing something and I want to take your drug test. How is that allowed? Well, we'll look at a couple cases that describe that. Amendment 5, at the bottom, we talk about not to be deprived of life, liberty, or property without the due process of law. What is due process of law? How do we guarantee it? So we'll be going through in that aspect. Amendment 6, right to a speedy and public trial. Amendment 7, no fact tried by a jury shall otherwise be re-examined by a court of the United States. So when you look at these Bill of Rights and certainly go through them with your notes, there's a lot of stuff that fit into the sport and recreation area. So we looked at constitutional law. We looked at statutory law, constitutional law, common law, now statutory law. Statutory law are laws created by state and federal legislatures. Oftentimes they're called statutes. Statutory law, statutes. Under the Supremacy Clause of the Constitution, federal law supersedes the conflicting state law, meaning the U.S. Supreme Court governs all statutes. Or if the Congress creates something and it's not unconstitutional, that law would be accepted and supersede all state laws. Some common statutory law that applies to sport and recreation, Title IX, both within an access for females for sport, but also we're looking at Title IX issues the last couple of years in terms of sexual assault and violence on campus. We have the Americans with Disability Act, the Voluntary Immunity Act, number of different federal and state statutes that directly affect what we're going to be talking about this semester. Administrative law, rules and regulations created by local, state, and federal governments, by the administrative agencies of those governments, whether it's the IRS, OSHA, the Federal Trade Commission. How they create their own laws, their rules and regulations govern what we do. If we run afoul of one of their rules, if you get a letter from the IRS questioning your last tax statement, then you have to go through their hearings first. You have to take the problem to them and go through their appeals process before you're allowed to bring it into a court of law. As we look at this idea of legal research, I've assigned you cases to brief. And those cases have these things named legal citations. And a legal citation really is an address. So you look at the first one that says Doe versus XYZ Corporation. That's the case name. It is Doe versus XYZ. So Doe is the plaintiff. If there are more than one plaintiffs, it could be Doe, Ray, and me versus XYZ Corporation. It's still just going to be listed as Doe. Same thing with the defendant side, XYZ Corporation and ABC Corporation. It's just going to be known as XYZ. Now, there's a couple of cases that we'll look at. Smith versus Gardner is one of them, that the main issue deals with a defendant that's not listed in the title. We have to find that out and really generate that issue and discuss the main legal issue in that case. 555 is a volume number. If you imagine going into a law library, that would mean that there's at least 555 books all filled with holdings from cases. This Doe versus XYZ, this case name, the citation, directs us to the ruling that the judge wrote down. So we go to the 555th volume of F2D, that's the name of the reporter, that's the name of the book. There's many different titles of these books that collect these different court rulings, and turn to page 777. With our online databases, it's much easier to do that. If you go through Westlaw or LexisNexis, you can just type in the citation and it'll pull it up for you. But the way they got this address is walking into a huge law library and finding these books. So if you imagine this as a regular street address, 555 would be the house number, F2D could be the street, and 777 could be known as like the apartment number or the floor. I'm using the lecture notes that I've had from on campus classes. So some of these cases I'll just skip over knowing that we don't have them or I did not send them out to you. Court systems. We have a state system with trial courts, courts of appeal, and state supreme courts. We have federal system with district courts, federal trial courts, and courts of appeal. All of them lead into the U.S. Supreme Court. There are 9 justices on the Supreme Court, and the Chief Justice's name is John Roberts. To be a justice, you do not have to be a member of the court previously. When William Rehnquist retired, the then President Bush decided to nominate John Roberts for the Chief Justice position. He was confirmed by the Senate. All the justices are appointed for life. So as long as they'd like to keep their job, they're allowed to keep it. They could retire, and then the standing president would nominate a replacement and have to be confirmed by the Senate. Trial courts and appellate courts. Trial courts are courts that decide the evidence of the case. They're the ones that decide the fact finders. They decide this person we believe, this person we don't. We find in favor of one or the other. An appellate court doesn't review new evidence. It doesn't listen to the witnesses. It doesn't go into the facts again. It doesn't retry the case. What it does is it focuses on a question of law, application, interpretation, and constitutionality. So it looks at, was the correct law applied? Should the law be changed? Is the law unconstitutional? What the appellate court can do then is it can uphold the decision, which means we agree with the trial court, everything was fine. It could reverse the decision and say the trial court applied the wrong law, it's overturned, that we're going to decide completely the other direction. Or it could be known as remanded. It could interpret the decision and then send it back to the trial level to be retried under this new interpretation. This is what we learned coming up in Nabozny versus Barnhill. Nabozny versus Barnhill is a case about co-participant liability. At what liability, what duty do we owe another player in a sport? Up until the mid-70s, if there was any injury or any illegal contact between the two people and there was an injury that occurred, it would just be considered an inherent risk. You're playing the sport, you're going to get hurt. In Nabozny, the court decided perhaps there's something a little bit different. Perhaps there's a willful, wanton, or reckless disregard for the safety of others that would create a liability. So if you would just punch somebody, or if you'd kick somebody and it's outside something that would be considered within the sport, such as soccer. If a person has a ball and you kick them, that's outside the rules. That could be considered willful, wanton, or reckless disregard for their safety. So in those areas, the Nabozny court says, the person may be liable for the injury. So they sent it back to the trial to be decided upon that. So the trial court then had to decide on where the ball was. Did the person have the ball with enough time? Could the other person move away? Did it reach this level that we're going to have the person liable for the injuries of somebody else? We'll hear a lot about jurisdiction. States courts usually hear cases involving their state law. Federal courts have limited jurisdiction because the Constitution limits what the federal government can do. Has to have a federal law, has to have a federal question. It can have a diversity of citizenship. If somebody from New York sues somebody in Florida, you can get that case put into a federal court, which may have less bias. The term home court advantage really could come from the legal system. There are many courts in this country that will view things differently because of perhaps employment or general industry. Southern California is very liberal and protects intellectual property of individuals. South Florida has a lot of tourism aspects to it and protects that industry from different types of lawsuits. Federal courts also can hear specific things from the military or tax or bankruptcy law. Here's a case that happened, Butch Reynolds versus IAAF. The case citation 23 F3rd 1110 page from the Sixth Circuit in the United States, held in 1994. So what happened here is Reynolds was a world-class sprinter. He ran a race in Monaco. He tested positive for performance-enhancing drugs and was banned from future competitions from the IAAF. They're the organization that runs international track and field. He brings a case in Ohio against the IAAF, challenging their decision to ban him for 2 years. What the court in Ohio said, the Sixth Circuit decided that he could not bring that case to that court because the IAAF is in England. The race was in Monaco. The test was actually conducted in France. It had nothing to do with Ohio except for Butch Reynolds was from there. It was not fair in that aspect to bring the IAAF all the way over to an Ohio court. The Ohio court decided it did not have jurisdiction. So you can have jurisdiction based on subject matter or geography. Here it's a little bit of both. It decided it didn't have the ability to hear it because the subject matter was overseas, and the fact that it didn't qualify because the organization had suitable contacts within the Ohio jurisdiction. Typical state court system has a state Supreme Court overseeing different courts of appeal, different district courts or trial courts. Some city courts may have a combined criminal and civil. There may be special courts in some areas that have focused on family court or traffic court. So they can be set up a little bit differently at the trial level. Federal court system has the United States Supreme Court at the helm. You have courts of appeals. You have 12 circuit courts as well as a federal circuit court in District of Columbia. A circuit court is similar to a state. It's going to cover multiple states, but the United States in the federal system is broken up into 12 different sections. So a court in the First Circuit does not necessarily have to follow the same precedent in the Third Circuit or the Seventh Circuit. Each one of those will be different, much like each state law can be different, until an appellate court overseeing multiple circuits or the Supreme Court decides to rule on a case, then the precedent would be set for all the circuits. There's administrative agencies, the National Labor Relations Council, Federal Trade Commission, IRS, different federal district courts, special federal courts with the military, all similar systems between the state and the federal system. U.S. Supreme Court is made up of 9 justices, the Chief Justice and 8 associates. They're appointed by the president for life. Their decisions are binding on all other courts. It can only be overturned by a U.S. Supreme Court decision to overrule it, or the Congress can pass a law that would then could be challenged by the Supreme Court for constitutional purposes, but that's where that checks and balances can interwork. Criminal courts are courts that are cases that are brought by the people. So you'll see something like the state of New York versus a person's name, or U.S. versus somebody's name if it's a federal court. So the state or the people bring charges against the defendant. The proof in a criminal court is beyond a reasonable doubt. So a prosecutor must prove his case beyond a reasonable doubt, almost 100% certain, in order to convict a defendant on a criminal charge. There's also civil courts. This is what we're going to learn very quickly in our tort system, civil lawsuits. These are disputes between individuals, corporations, business entities, non-criminal matters. A plaintiff brings a claim against a defendant. Here, the plaintiff must prove the person is liable based on a preponderance of the evidence. 51% certain. And that's a typo on that. I apologize that it's not prosecutors. It's the plaintiff must prove the person is liable based on a preponderance, which is 51%. When you think about the difference between 100% and 51, it's very striking. This really is one of the interesting aspects of the famous O.J. Simpson murder trial, where in a criminal court, they could not prove it beyond a reasonable doubt, but in a civil court, he was found liable for the deaths of the girlfriend and Ron Goldman. In a lawsuit, you start off with a complaint. That's allegations by the plaintiffs. This is what I think you did. Based on this law, I should be entitled to these type of damages. The response by the defendant is called the answer. They both go through a discovery phase where you depose witnesses on both sides. You create evidence. It is not like the movies in many aspects where one side is hiding information from the other. In fact, if you hide information, you could face extremely high sanctions from the court. You go through some motions. You can make a motion to dismiss the matter. So perhaps at this point, the defendant says, you know what, there is no legal basis for this claim, and I ask the court to dismiss it, which may be granted. The plaintiff could ask the court the same thing. It could say, the defense has no real defense. There's no way that they're going to win. I would ask for a summary judgment on this. So the court at this point could dismiss or grant a summary judgment, meaning here's the decision before we even go to trial. You can go to trial, which includes jury selection, opening and closing arguments, direct and cross examinations. First the plaintiff goes, then the defendants, then closing arguments, back and forth. All during the trial, you can have a plea agreement or a settlement. And then once it's decided, you can have some appeals. When we look at legal resources and do some research, we talk about primary sources. The primary source is the actual law, the U.S. and state constitution, the federal and state statutes, court rulings or the common law, regulations. From the 4 different areas that we talked about to create law, those are the actual law. That's a primary source. That holds lots of precedence and sway within the court. There's secondary sources, and these are more commentary on the law. Perhaps there's one law in New York and very similar fact pattern. Law is different in Florida. So a academic may write a law journal article on it, comparing and contrasting the two. So you can write law reviews, journals, textbooks. All of those really are commentary on the law. They're not the law itself. It's secondary. A court may refer to it. They may agree with it, but it doesn't hold the same weight or the same priority as primary law would, certainly if that primary law is created within that jurisdiction. How do we find legal resources? We can use LexisNexis and Westlaw. I encourage all of the students to go into their academic portal and use LexisNexis. Use the citation that I've given you to search for it through LexisNexis. If you have questions, you can reach out to me. If you have a law library on campus, you can go to them and they can help you out a lot with that. I recommend going to the legal aspect. Get the primary law first. Then, in order to understand it, you may want to do an internet search through Google or Dogpile or something to better understand it. But get the law first. Get the primary source first. There's a lot of benefits to this. You'll get the correct one. You'll understand it better. Perhaps the secondary source that you find, the journal, isn't up to date. Maybe they referred to and commented on an earlier decision that upon a later appeal got overturned. So you're going to be reading about the wrong case. go to the law first, especially if you're going to be able to generate legal research once you get employed in any different aspect that you'd want. And then I sometimes assign a legal system assignment. I'm not assigning this in our classes here. However, if you want to do one or the other, if you've ever had a chance to go to criminal or civil law, go to a law hearing, go to the courthouse, spend an hour there. It's really interesting. Think about that. We're allowed to go as a person in the general public and watch this happen. This clearly wasn't the same thing in colonial America where a governor or judge could decide anything that they wanted. Certainly something that isn't afforded to everyone in the world. You can also research your home court system, diagram the system, find out different names and locations of different courts. I hope this introductory discussion on this PowerPoint helps you. If you have any questions, certainly get in contact with me. Thanks.